Is your motion? What do you have to add to it?
I'm wondering if you got those check stubs that I've entered in.
I didn't get any check stubs.
So
Oh yeah. Wait a minute, I did get some check stubs. Yes, you were the one that did have them. Yeah, I had a question on those because you got two support notices on each stub. So do you have more than one case?
yes, sir.
Okay, how many children do you have?
Two.
Okay, this one and another one.
Yep.
Okay, because I was trying to figure out. I have a feeling that what's happening is they are maxed out on how much they can take out of your checks. The reason that you keep getting hauled in is because you're not paying the full amount of child support.
But at the time that they was taking the money out of my checks, they
Right,
issued the warrant.
right. If you owe
And
$100 and they only collect 70, you're gaining $30 a month in arrears. And once the
no,
arrears hit a month, well, that's why I was asking because the amount of child
those
support that is are these weekly checks or monthly?
weekly, sir. It's
Okay.
440. They was receiving that. And at the
And
time,
how much did they say that you owe?
just now recently,
Yeah.
they said I was in arrears 5,000.
Okay. Yeah, because I have a feeling that's what's happening. Now
But
you have the right to have this child support reviewed at this point in time. It's been 3 years since the last order, so it can be reviewed for you.
but my whole thing is, um, I wasn't paying because last year, April,
Hmm.
they got a $5,000 check on my behalf
From whom?
from an employer, from a settlement, which was from an employer.
Okay, and they confiscated all 5,000.
Yep, it was
Okay, and that should have gone against any arrears. Now their next question would be, are you sure they got it?
child support.
No, the $5,000 check.
Child support got that $5,000 check.
Are you sure they got it?
Yes, I'm sure they
Okay,
got.
because what I would do if I were you is ask for an accounting of the case to make sure they got it. An accounting will give you a computer readout of every month that you
Ouch.
owe and every payment that's been made, and they do it in writing. So if you write them and ask for an accounting of your child support, because some of this stuff will not be in the court file. The court file is a public file. So the court does not know how much your arrearage is unless they apply for a show cause. Okay.
Okay, and I haven't been paying recently because I was under the impression that the obligation is 445 a
Well,
month.
it looks like how have you not been are you not employed anymore?
I'm at work right now.
Okay. Well, it's because the employer automatically takes it out.
Right. I just started this job, and
Okay. Okay. Then you have to notify the front of the court what job you changed to so that they can apply it to the appropriate because they issue an automatic income withholding order. Again, that does not go in the court file because it contains very specific information about you, and you don't want that public information.
this is what I'm trying to say to you, sir.
Hmm.
They received $5,000 last
And I told you what to do to deal with that.
April.
Yeah.
I was under the impression cover the rest of the year. I did not know that they still
No, they don't cover anything forward. They only cover things currently owed.
right.
They
Okay.
can't hold money forward if they have an overpayment within 48 hours. They will send you back a check for the overpayment.
Okay. Well, they still was in breach of contract.
There is no contract. This is the law. That's not a contract.
Is this
They're
Zoom
following.
just about child support?
Yeah, sorry, Miss Cry. That's what his motion's about.
And
So,
why did I have to join? I'm thinking this for my
well, because
motion.
you have a motion.
Yes, I do.
I have a motion for child support and an amended motion for child support. Those are the only motions before the court.
My motion wasn't about child support.
What was your motion about?
It was basically just for me trying to get his rights and stuff revoked. I did all this
We
stuff
we
like
we we don't revoke rights in a parent in a family law case.
you should have been getting some paper. I
It
did
won't
all this
ma-
stuff
well,
last
that
week.
that motion would be automatically denied because we do not revoke parental rights in a family law case. That has to be done in a neglect case,
In a what case?
an abuse neglect case.
So why did they have me filling out the papers? And I told
I
the
have no idea. I don't know what papers you filled out. I don't have them.
mm,
Okay. So I'm sorry, I didn't know you had a motion. But I was going to ask for your input before we finish this. I'm just trying to deal with his issues on child support.
okay.
He seems to be under a misapprehension that this is a contractual relationship, and it's not. It's a statutory relationship.
Okay.
The front of the court is following their statutory authority to collect child support on behalf of the child. So that's what's necessary, and they will automatically follow their rules and the statutes in doing so. The court tells them when or if child support should be reviewed. And again, I've informed you, sir, Mr. Miller, you have the right to ask for a child support review if that's what you're asking for. But yeah, if you're not paying support, they're going to be hauling you in to explain why you're not paying.
Well, I also was sick.
Okay, that's fine too. But again, you're going to have to explain why the payments weren't being made and why you owe.
Payments wasn't being made because I was under.
You're under a misapprehension, not an understanding. So that one I could tell you you're wrong on. So the best you can do is ask for an accounting to make sure that all money is accounted for and all payments are accounted for. Now, do you want this sent to the front of the court for a child support review?
I want this case closed and dismissed.
It's not going to be closed and it's not going to be dismissed.
So even though they were receiving the full monthly obligations, it's okay for them to.
If you owe, they're going to haul you in to find out why you're not paying the amount.
And we wasn't receiving I wasn't receiving no full
Well,
amount of no
ma'am,
child support.
part of this, you're not going to receive the full amount. You're on state aid. The reason that this case was brought, it was brought by the state of Michigan because of your state aid. When you're on state aid, the state mandates the child support be paid in accordance with the law, and then they confiscate portions of that child support to reimburse the state for what they're paying on behalf of the child.
Is this Admiralty Maritime Court law?
No, it's not Admiralty Maritime Court law. This is the state of Michigan. We are not in the middle of an ocean.
Because the flag in the back got a gold fringe on it.
Yeah, don't even do that bull. That's a bunch of bull.
You have.
It is a United States. I don't know what you're receiving, ma'am, but this case was brought by the prosecutor's office on behalf of DHHS because of state aid involvement.
Oh, I don't receive anything. I haven't since like
okay. Well,
summer.
then once you stop that, then you should be receiving the full amount, but the state will confiscate part of anything that's still owed to them from any child support collected. Right now, I'm not sure how much the arrearage is. Obviously, there is an arrearage. So, no, the UCC, the Uniform Commercial Code, does not apply to this court, sir. This is a family law court.
That you don't have on the gown either, so you're not.
You're right. That's because I'm an appointed judicial official, not an elected judicial official. So yes, I have a full authority. I am sworn in. I am an attorney prior to being in my judicial capacity. So yeah, I have full authority, and the authority is given to me by statute as well. So I follow the statutes, the laws that I have to follow.
So this statutes and codes, it's not actually law.
It's not code. It's law. It's statutes. It's the laws of the state of Michigan.
Statutes and codes.
Statutes, no codes. The Uniform Commercial Code does not apply to this court.
Ouch.
All right. Do you want the child support review or not, sir?
I do want the child support review.
Okay. In that case, I will send this for a child support review. Ms. Cry, any questions, ma'am?
Nope.
All righty. I will look at your motion when I do receive it, ma'am. I don't know when it's scheduled for, but it was not scheduled for this morning. Okay.
Oh, that's what I thought this was for. Okay.
Yeah, no problem. This was for his motion.
Uh-oh.
All right.
Mm-hmm.
Have a good morning to both of you. I'll send this to the front of the court for child support review. Have your most recent current pay stub available. Both of you.
I'm under the impression that there's a warrant.
You do have a warrant.
I didn't notice a warrant, but that wouldn't come up on this file for this motion. That would be a separate issue. You might want to call the warrant department if you believe there's a warrant, because you can deal with that.
Okay? I wasn't properly served on.
Again, the court has no paperwork concerning any of your warrant. I don't have her paperwork for her motion. I can't advise on things that I don't have before me because I need to look at them before to find out if they're properly served or not. Call the warrant office and find out what's going on. If you believe there's a warrant, this is the first I've heard of it.
This is the motion for support.
This is the motion for support, and that's why I'm sending it to the front of the court for child support review.
And this all is under the same thing. Why they issued the warrant? Supposedly.
No, that's separate issues. This is ongoing support. Your warrant is about back support, if there is one. Okay. Yep. Two separate departments. All righty. Good luck. Have a good morning. Take care, everybody. Motion's granted for support. Review. Okay. Admiralty Court. I love it. Let me get my... Okay, Ms. Jones, did you connect?
Okay, next week.
Yeah. Am I? Yes.
Yeah, you're there. You're here.
Okay.
Mr. Keys, did you connect?
Oh yeah, I was muted. Yeah.
No problem. All righty. So we are here in the matter of Jones versus Keys. I've read your motion, sir. Is there anything you'd like to add to it?
No, sir.
Okay. Ms. Jones, any questions? This is a motion to review child support. Child support could be reviewed under a change of circumstance that occurs through no fault of the parties. In other words, an up or down in income through no fault of their own. Like we based it on a lot of overtime and now the overtime's all gone, or it could be done every 3 years. In this case, it's just over a year that we did the support last time, but it appears to be a justifiable change of circumstance that his income has decreased.
Okay.
Okay, so that would be a proper change of circumstance to have this reviewed. So I'm going to grant his motion to have the review. All right. Any other questions from either one of you?
No.
All right, just have both your most recent pay stubs available, probably your last pay stub from last year if that's available. That's generally the best one, because what they do is, the earlier in the year we have it, the more inaccurate it is, because they'll take like last week's pay stub, which would be like the 6th week, divide by 6 and multiply by 52. So the more weeks you have, the more accurate it's going to be for a year. So have your last pay stub. The W-2s really don't help much anymore. They're off by about anywhere from 5 to 10% because income is hidden in subsections 12 and subsections 14. So it used to be as accurate as we could get. And once they changed the tax laws in 2017, it's no longer accurate as to gross income. The program plugs in gross income and then takes out all the taxes and figures out what your actual net income would be. And then that's what you'd calculate support on. And sir, under these facts, it's going to be based probably 98 to 99% on your income. So her income is going to be necessary, but mathematically not that big of a deal. Okay. What they want to do is accurate as possible. So I'll send this to the front of the court. Good luck, everybody. Have a good morning.
You too.
Okay. 3DS. Starting off with two support ones. Wow. One concerning child support and one concerning parenting time. The file's a little confusing. It appears there was a hearing in November on November 4th and an order issued on November 5th. There was also a child support order that was entered in August of 2024. So, Ms. Robrand, you say that the parties came to an agreement on parenting time, but that was in August of 2023. So that's been over a year.
That is correct, Your Honor. Their previous counsel, they entered a stipulated order on the 8th of December in 2023, and that is the parenting time schedule that the parties have been working from.
Right, but that gives him 0 overnights.
That is correct.
And the reason for that was because he had a roommate of some kind?
There were a variety of roommates in the home that he is still living in that were raising concerns at the time.
Okay.
And the parties agreed to have 0 overnights.
Understood. His motion says that he no longer has any roommates. Is that true, Mr. McNabb?
Yes, the family that was living in the basement did move out. I do rent a house.
But is that separate from where you live?
No, I live there. Yep.
Okay.
All the roommates are done. They're out of the basement. They were staying there while their house was getting built. And
Okay.
that lasted a little longer than anticipated. So I agreed
All
to,
right. Yeah.
abolish the overnights until they moved out.
Ms. Robrand, under number 6 in your further response, it says that even if there are circumstances that have changed in defendant's life, that's not a proper basis to request a modification to parenting time. Normally, you might be correct, but if the situation in his life was what caused the parenting time to be deleted, and that now has been eliminated, then that is a proper circumstance to then review parenting time.
Okay, there's a couple things here, Your Honor. He's still living with one of the gentlemen that were raising concerns at the time that the current order was
Okay.
in place. He's still
Okay.
living.
Is that true, sir?
Yes, Roger Cooper lives
Okay, in
there.
that case, there is no change of circumstance. I can't review parenting time. If the circumstance that
I've always tried to spot from him, even years before
but
it happened, and he's never there on the
look,
weekend.
you guys entered the order because of concerns. If those concerns still exist, then there is no change of circumstance to review the order. Your motion kind of indicated that all the roommates are gone. So I thought we might have had a change of circumstance, but if the roommate's still there, that was a cause for concern, we don't have a change of circumstance to review this.
Okay. All right.
Sorry. That's why I was trying to get to the nuts and bolts of this, because
Lived there for years, and I've just always been on the.
I read the case. I wasn't sure
Never
exactly
been-
what was going on because, like I said, the file's a little convoluted. That's why I had some questions. But it did appear that the order was entered into because of concerns of some people you lived with. And now I'm being told your motion indicated that those people are gone. Now you're saying that no, and they're saying that no, the guy that they had concerns of is still living there. Therefore, the condition that caused the parenting time order to be entered as it was still exists, and I can't change it. You guys signed it. You guys agreed to it. Now if that change happens and he's no longer of concern, then I can look at parenting time. But the concern's still there. Whatever it was when you guys signed this, you guys signed it. You guys did it. So obviously there were concerns that everybody had, or at least we're willing to oblige.
Okay, I apologize. I assume
no, that's okay. I mean, normally what I would tell you is if you have limited parenting time, the court will look at it every once in a while. Every 6 months to a year, we'll kind of revisit it because it's the child's right to parenting time with the parent, not necessarily the parent's time. I mean, not necessarily the parent's right. It's the child's right to know both parents. But if there are conditions, it's got to be done safely. And if there are concerns and those concerns still exist, I'm not touching what you guys agreed to. As to the child support, I'm not sure. Ms. Robrand, it looks like it was based on $79,000 a year.
I did not enter that order. That is something that Attorney Swears did at the time. And
Right.
based on the numbers from the friend of the court. So the friend of the court did their review, and then Attorney Swears went in and did an amendment because Mr. McNabb was having trouble keeping the children on his health insurance. So we had to take another look at it.
Yeah, I saw that issue. My question was, I was trying to figure out what it was based on. In the file, it says 79,000. He's saying that he only earned 69,000.
We have no evidence.
I know. I don't have evidence of that either. That's why I was going to see what I could do about that portion, because we do want to get that right. Sir, the income withholding orders are issued by the front of the court in accordance with the court order. So no attorney issues those. Those are issued by law, and they are never put in a court file because they contain information that you don't want made public. Court files are public documents. Anybody in the public can come in and look at them. So there are certain things that are constrained from the court file itself that only the front of the court will have because of personal information contained therein. Sir, if you could, I believe you have my contact information through my clerk. And what I will do is, ma'am, if it is significantly different, if it was based on 79,000 and his income was 69, I may send it to the front of the court for obvious reasons, because then we have his income wrong by a very high percentage. So that would be a change of circumstance that was not considered at the time that this was entered. And I realize it was only entered in November, or August. So, change of circumstance is a change of circumstance every 3 years, or a change of income. And if we've got the income wrong, that's a change, and I want to get it right. But the orthodontia is a whole different issue. That's something over and above. And that's also in the court order under the percentage of healthcare costs. That was obviously somebody did a hearing, or somebody agreed to because the front of the court will review that find out how much it is, and then, yeah, it will automatically be taken off. They don't put the final number on it. They just add it until it's to be taken off, and then they remove it. Okay. Yeah. So I don't get, I think probably in the 18 years I've done this job, I've seen 3 income withholding orders. So the court doesn't ever get to see them. So because of the information that's on them. So, because what the court sees is going to probably go into the court file. So I don't want to do that to you. But if you could send me a copy of your most recent pay stub and your last year's pay stub. I'll need his, I don't need yours, Miss Lutz. I need Mr. McNabb, I need yours, because if it is that change, I am going to send it. So I'll reserve on that issue,
Okay.
pending proof that we have a change of income. Okay.
Yep. Okay.
Alrighty. So email that to my clerk, and Ms. Robrand, I will email you a redacted copy. And sorry, you can redact anything appropriate on it, like social security numbers or addresses you don't want anybody to know. You can also redact it. I just need year-to-date total and the pay date, not the check issue date, the date that the pay goes through. Okay. All right. All right. Any other questions?
Your Honor, there was one other thing. There is, defendant does owe plaintiff $350 from an outstanding order. I don't know if the court would be willing to address that today. That wasn't a relief paragraph.
Right. I didn't see that as a relief paragraph. I was going to say, what is that from? That's from the show cause last November.
That is correct. He still has.
Did Judge West put a time limit on that?
It was 2 months.
Okay. If the 2 months have elapsed, Mr. McNabb, get that paid. Otherwise, then it's another show cause, and that's going to cause more costs in hearings. So, all righty.
Trying to get the money. I guess while we're here, they added on an extra $375 a month to my child support for out-of-pocket dental expense.
Yeah,
There's
I just brought that. I just explained that to you. That's orthodontia. They put it on there, and they'll automatically take it off once it's paid.
Okay.
Once it's done.
All right.
Yeah, that was that explanation earlier. Sorry, I jumped ahead. There's somebody like 350s and 370s in here that are mentioned. I'm like, I got confused. Anyway, because I just got your response yesterday afternoon, Ms. Robrand.
Oh, my apologies, Your Honor.
No, that's not your fault. That's I was on vacation till Wednesday. So
well, I hope you had a wonderful time. Welcome back.
yeah, my wife did the Princess 5K, 10K, and half marathon.
That doesn't sound like a vacation.
Was for me. I slept in. I did the 5K, and it was 39 degrees in Florida.
Oh, wow. Okay.
You have to jump in the corrals at between 3 and 3:30. It was 39 degrees. The race starts at 5:30 to 6 o'clock, depending upon what corral you're in. And it got up to a whole whopping 41 degrees before the 5K was over.
Oh, wow. That's cool for Florida.
So, in any event, I got a nice medal out of it. So,
Well, congratulations.
Yeah, my wife got 4 because you get a medal for each race. And if you do all 3 races, you get a 4th medal called the dopey. For obvious reasons. All right.
Well, thank you very much.
Take care. It was nice meeting you. Mr. McNabb, get that to us as soon as possible, okay?
Yep. Sounds
Take
good.
care, sir. All righty. Bye.
Bye.
0653DS. At this point in time, I've read the motion. I don't know if anything else needs to be added to it. Every party has the right to ask for specific parenting time at any time. And pursuant to case law, especially Kent County case law, because it was a case out of Kent County that indicates that legal custody was given by statute, not by court order, Ms. Robinson. So that can be looked at appropriately. Now, whether he gets it or not is a whole nother question. He still has to jump through some hoops, but it can be looked at. So that's the law. Is there any questions that you have, Ms. Robinson?
Yes, I want full custody of my son.
You have full custody. You have full physical custody. Legal custody you have by statute, because a child born out of wedlock legally and physically has only one parent. That's the mother by statute. When this court order was entered, the court order gave you physical custody, but it left blank legal custody. This case was brought by the prosecutor's office because child support, DHHS was involved, state aid was involved. So the only thing the prosecutor can deal with is child support. And child support under federal law has to be attached to someone who has custody. Therefore, they make sure that they follow through with custody is yours. Then they give child support. Legal custody they will not touch, and they will not touch parenting time, which is why both of those issues are left open.
Okay.
Okay.
Malcolm, should not have parenting time at all.
Well, he has the right to ask. Whether he gets it or not, again, is a whole other matter.
Okay.
This is just that what I'm saying is by law, he has the right to request these things. He has the right to have them reviewed. That does
Okay.
not necessarily mean he gets it.
Okay.
The law presumes that parenting time will occur. It's the child's right for parenting time to know both parents.
Okay.
Okay. So if it can be, as long as it can be done safely, parenting time will be granted to him. Now, if you can show that it's unsafe in some way, shape, or form, that would constrain it. But if it can be done safely, it's going to be granted by law. I didn't get to choose the parents here. You guys did.
Yeah, no, he's not a safe person. That's what I'm
Well,
saying.
that's what
Environment.
that's what you're going to have to show the front of the court.
I will.
Okay. But that's then those later arguments. The front of the court will be contacting you all shortly. In reviewing the income levels of both parties in this case, I realize this was done by an attorney, but I'm going to waive the filing fee for. Normally it's $300, $150 each. I generally assign the $300 to one person because otherwise it doesn't get paid. But in this case, I believe if a fee waiver had been requested in this matter, it would have been granted. So I will waive the fees. Okay.
Thank you,
Any
Judge.
questions? All right. So I will send it to the front of the court for a review of legal custody and a review of parenting time. Any other questions?
Perfect. Thank you, Judge.
Okay. Any other
No.
questions? Ms. Robinson, I'm sorry.
You didn't give me a chance to speak.
I thought I did, but okay. That's why I'm asking you now. Anything else, Ms. Robinson?
No, I was talking to Ms. Johnson. What's the next step? This is my first time.
Okay, the next step is I'm sending this to the front of the court. The front of the court will be contacting you to discuss the issues. Okay. To find out what's been going on. You know, they're going to have to review the custodial environment. And if they're, you know, obviously, if he's never made any legal decisions for the child, they've all been yours. The legal custodial environment is probably going to be with you. He needs clear and convincing evidence to then get any legal custody. As to parenting time, you have the burden of showing by clear and convincing evidence that he's a danger to the child.
Okay.
All right. Both of those are high burdens. So, but each of you have one. Okay. That'll be the next step. The front of the court will meet with you, and they generally get through about 80 to 85% of our cases because they can hear things that I sometimes can't because the rules of evidence apply if you're in my courtroom and we have a hearing. The rules of evidence don't apply to what they hear. They can hear everything you want to say. Okay. All right. Good luck to both of you. Ms. Johnson, there wasn't much for you to say. You filed the appropriate motion. It's kind of like an automatic. And
I explained that to my
yeah,
client.
I figured you explained it to your client. I was giving Ms. Robinson a chance since, you know, like she said, this is new to her. So I wanted to make sure I kind of clarified as best as I could for her.
Understood, Judge.
All righty.
Enjoy your weekend. Thank you.
Take care, everybody.
Thank you.
Motion. Any party has the right to request specific parenting time at any time if there is none. There is none in this case. So you have that right, sir. I have no choice but by law to send it to the front of the court to review. Ms. Bonnet, so that you understand, parenting time is going to be granted because it's presumed to be in the best interest of the child, and it's the child's right to have parenting time and know both parents. Sure. It's got to be in the child's best interest, and it's got to be safe. And as long as those two things can be done, parenting time is going to be granted. Sir, I don't think you're going to get every other week. That's a change of custody.
Yes.
Not a request for parenting
time.
That's
what I was agreeing to. I'm definitely going to agree to 2 times, 2 weekends out of the month.
You know, let's face it. All we have is weekends when the kid's available and evenings. So there's going to be, depending upon how far apart, as long as you don't live like 2 hours apart, there's going to be a couple evenings given during the week as well. You know, that way, when the kid becomes a teenager, you each become a taxi service. That's what happens as they get older. You know, right now it's fun. Right now it's fun time, but later on, when they have sports and stuff, that way both of you can get a break and both of you can have your car smelling of sweat and all kinds of stuff when the team gets in there.
Well, if I can get them every other week, I'm fine with just the weekends.
Well, that's fine. But what I'll do you guys think you could sit down and talk to somebody? Because otherwise I'll send it for parenting time mediation and they'll write up the agreement for you. That way times and dates are set.
Only reason why I put a motion in is because I try to.
That's okay. It's okay. Relax. You know, you sometimes you got to ask for what, you know, the moon, and then you get something. You know, at least you get off the earth. So in any event, let's get you the parenting time. But I'll send it to mediation if the two of you get along well enough to do that, because then they'll put it in writing so that you know times and days. That way the child knows what to expect, and so do each of you. Okay. And holidays. I mean, holidays are involved in there too. Because holidays are about not just you, it's about them meeting their cousins and their grandparents and the rest of their family. I'm assuming.
I agree.
Yeah, you know.
Yes, but I
Okay.
definitely
Well,
agree to the two times out of the
yeah,
week, out of the
yeah,
month.
yeah. Well, I will send you to mediation. You guys can sit down, and if the mediation works, great. If it doesn't, then I'll send it to the front of the court for a full review. But we'll hold off on that for now. Okay.
Thank you.
You two take care and take care of the child. It's nice to meet you. Have a good morning. Sir, I've read your motion and a lot of the attachments. Most of the stuff that you sent in involves stuff that happened before the last court order.
Yes, but it's to show a pattern of habit over the last 2 years.
Oh, well, unfortunately, it's irrelevant to this motion because I need something that happened since the last order for a look at parenting time at all.
That's fine. There's other things I've seen that did happen since then.
Well, yeah, but there's nothing here that would require a look at parenting time at all. You don't meet any legal standard under the case Shade versus Wright.
She's moved out of state.
She's not moved out of state according to her response. Did you read her response?
No, I didn't actually see a response from her, but she has.
The response is she has not moved out. Are you still receiving your parenting time?
I am, yes.
Okay, that's kind of it. Has is this child in school?
They are.
Okay, is the school changed?
Well, no, but she still moved. It doesn't have anything to do with the school.
Has everything to do with the school. If she's taking the kids out of state, she can go out of state and visit somewhere if she wants.
I didn't say she took the kids out of school.
Well, that's what matters. As long as she can do with her life what she wishes, as long as everything in the order is being followed. She can't leave the kids with anybody but her. So I'm assuming her response is she's not moved. She had thought about it, she had talked about it, and decided not to, and she would have to ask this court's permission. The court may let her move, but we may not let the kids move, which would then justify your request for a change of custody. But without her moving, you don't have that change of circumstance.
But she has moved. She comes back for the weeks of the kids as of now, but her address is up there. Her phone number's from up there. She lives there.
She is denying that. What evidence do you have that she moved there?
Her phone number, for one, is an area code from that area. Two, when you look up her name, it pulls up her address, which is actually the address she lives in with Ryan Neese. And three, I know she moved because she's mentioned she has it. She just comes back for now on the weeks she has the kids. She comes back.
She has a home here?
She lives with her mom when she's here.
Okay.
But it's not her home. She just stays for the week. But she comes back late on Wednesday.
But she takes care of the kids in this area.
Well, her and her mom and anybody else that she can get to help her, yes.
Okay, so nothing has changed. Again, no change of circumstance. Well, legally, I'm sure you do disagree, but legally, I can't grant you what you're asking for. Well, the next portion, you want her name off the property. You're the one who's responsible for drafting the quitclaim deed for her to sign.
That was what the judge told us. He said that she had 30 days from the divorce to get it off, which she did yesterday at 4:33 p.m.
Technically, the rules are that you supply the quitclaim deed for her to sign. That would be the normal.
It wasn't what the judge said, and it was never mentioned. So
I understand that, but that's not normal procedure. So, and I don't see it in the order. I just see that but in any event, if you get the house, you have to do the paperwork. Trust me, I was a divorce attorney for 10 years before I did this job. That's normal. Yeah. Well, you were represented at the time, weren't you?
No, I represent myself.
Oh, that would be the problem. Okay. Never mind, your attorney would have known better. Okay. He would have probably drafted the quitclaim deed along with the judgment, and that would have been. But yeah, under those circumstances, it sounds like your motion to enforce has been granted by operation of the fact that she did it. Which she didn't have to do. It should have been you, but I'm glad it's done. Probably her attorney just said, let's get it done and did it. Ms. Grauman's good for stuff like that, and so she moved that obstacle out of the way. But as to the requisite change of circumstance to make the changes that you're requesting, if she moves and moves the kids, I get you. That's it. But if she has not moved with the kids and everything's going the way it was, there's no change of circumstance. So I have to deny that motion legally. All right. Okay. Good luck to both parties. Have a good morning.
Thank you, Your Honor.
Would have helped had he have read the response, which shows that she didn't move. And if she wants to spend time with her boyfriend when she doesn't have the kid, that's her prerogative. Anyway, next. All right. I'm a little confused.
Sorry,
Yeah.
Mr. Oh, he left
He's-
and then came back.
Okay. Still with us, sir? You left for a second.
Yeah.
Okay. All right.
My phone been stupid.
All right. No problem. All right. So I'm in reading the complaint for divorce, Ms. Scarborough. You say you married in September of 2019, correct?
Yes.
Number 3, it says separated on or about, and your response does not have a date to it. It said walked out on me and his daughter.
Yeah, he walked out in August.
Okay, so August of 2024.
Yes.
And this child is 2 years old, and you were living together when the child was born.
Yes.
Now, are we only talking about Elizabeth?
Yes.
So that's the only child that you two have since you said I do.
Yes.
All right. And why are you saying that the child is not his?
No, my youngest is not his.
So that would be Rosie.
Yes. She's not his.
And she's 11 months old?
Yeah, she just told one.
And you were living together with him at the time, correct?
Not with Rosie, not with my youngest.
You said you separated in August of 2024.
No, we separated, he's been gone almost 2 years.
Oh, great. Okay. Sir, when did you leave?
Hello?
Hello. When did you leave?
Yeah, my phone been stupid. I had to connect. I'm connected to my stepdad's internet, so it shouldn't get off now.
Okay. All right. When did you leave her, sir?
In August.
All right. And this child was conceived when, Miss Scarborough? Well, you won't know the answer to this, I'm hoping, Mr. Scarborough, but I need an answer from her. When was this child conceived, ma'am?
Rosie, she was born February 26th.
I know when she was born. When was she conceived? I'm assuming you were there.
I don't remember what day I got pregnant.
I don't need a day. Can you give me a month?
A month. It was in October.
She was born in February?
Yeah. I got pregnant, I don't know the
Okay.
month.
All right. I'm going to have to order DNA in this case to confirm that he is not the father. Okay.
Okay.
All right. So I will issue an order for a DNA test. Normally the best place to do it is DNA diagnostics. Now, do you know who the father is, correct?
Yeah, my boyfriend is my youngest daughter's dad.
Okay. Mr. Scarborough? Thomas, maybe I'll have the boyfriend do the DNA test. That way we can kill 2 birds with 1 stone. We'll know you're not the father and we'll know he is. That way she can get him on the birth certificate after this.
Okay.
How does that sound?
That'd be fine.
All right, Miss Scarborough, does that sound okay?
Yes, Thomas is the father of my oldest, Elizabeth.
Right. That's because I was trying to figure out, because, yeah, like I said, the pleadings are a little bit off that we may have to correct when we finalize this divorce. Okay.
Mm-hmm.
Well, but we'll get to that at the next period. What I'm going to do is I'm going to set a hearing in about 7 or 8 weeks. Okay. I need you to get me the DNA results.
Okay.
Showing that the boyfriend's the father, and we'll call both of you back in. I'll put you under oath, and we'll get this order done so that Rosie is not considered Thomas's legal daughter. Okay? But I need the DNA results to confirm that, because there seems to be some overlap about when conception occurred and when you guys were living together.
Yeah.
All right. So thank you very much. I'm gonna grant the DNA
how
order.
do I do the? Do I have to come up to your courthouse to do the DNA test, or how do I?
No,
do
you're
that?
going to have to contact DNA Diagnostics. There's an office in Grand Rapids. Might be in
Okay.
Cascade. Just call them and take the order in. I don't know how. I think it's less than $100 now, so it's not that expensive. But you're
Okay.
going to need the DNA test, okay? And like I said, I'll have you and your boyfriend do it because that'll prove that he's the father and show
Yeah.
that Thomas is definitely not. There's no sense in doing a DNA test with Thomas to show he's not. Then you're going to have to get another DNA test for the boyfriend later. So let's save you some money and get one done, okay?
Yes, sir.
All righty. Thank you. Have a good morning. I'll issue that order on Monday. Okay?
Okay.
Take care.
Yep.
Oh, is he still there, Thomas? Is he still?
Okay. 1DP. Mr. Armstrong, this is your motion. Anything you'd like to add to it?
No, not at all. Yes. I would like for this birth certificate right here. It's an application to add father on a Michigan birth certificate record.
Right.
And so I have this, and I'm trying to see what Chelsea is willing to sign for my name to go, my last name to be on my son's birth certificate. Because I never had the option, none of that.
Yeah. Normally, you can use the court order from the prosecutor that makes you the father and states that you're the father and file that, and they'll put your name on the birth certificate. They normally like to have both names on it. Is there somebody else's name on that, Miss Sear?
Yes, he has my father's last name, which my oldest.
Oh, no. We're not talking about a name change because that's not going to happen.
Oh, okay.
By statute, you put the name on the child. He wants his name on the birth certificate.
No. I'm saying, is there any way that I got this form right here to add my last name to my son's last name, so my son can have it?
No. A child born out of wedlock, the mother gets to name the child. The statute's very clear on that. So you can file a motion to do that, but it's very rarely done. The mother would have to agree.
Okay.
But that's not the motion that you filed. You filed a motion concerning.
Yes, I know. Yeah, custody.
Yeah, because I mean, you filed a motion concerning, I believe, custody, correct?
Yes.
And really, it's a motion for parenting time is what you're really wanting.
Yes.
As well.
Yes.
Right. Okay. So, because at this point, custody has been awarded to her by that court order by the prosecutor. Why is... Okay. Somebody put the wrong case number on one of your filings. They mislabeled it. So yeah, the judgment of paternity was entered on December 20th, 2024.
Yeah.
So you are the father.
Yeah.
The name change is a whole bunch of legal hoops that you're going to have to jump through.
Okay.
You have the right to apply for it, but I can tell you it's very rarely done because the statute's pretty clear.
Yeah, I got it right here.
Right. In any event, Miss Sear, I got your response.
Okay.
You're saying he's not been that involved, correct?
Absolutely correct.
Okay. We do have a DNA test showing that he is the father, so he does have the right to ask for parenting time at any time. Because there's no specific parenting time.
Correct.
Okay.
Yep, I'm okay. I've been trying to get him involved since day one. He doesn't want anything to do with him. I've been trying, and it got to the point where I just didn't want to try anymore.
Like I said, I read your response. But now he's officially coming to the court to request, and the court has no choice but to move it along. So I will send this to the front of the court. Sir, custody is not going to change. I can't grant you custody.
Yeah, I know. Okay. That's what I was referring to at the time.
Right. Yeah. Some people file the motion for custody, and what they really want is just time with their child.
Yeah, and that's what I've been asking for.
I will send this to the front of the court with the fees waived because they've been waived by the judge for parenting time review. Okay.
Okay.
So they will be contacting you shortly. And then they're going to sit down and talk with each of you. Ma'am, you can address your concerns. Sir, you can address your desires and why you believe the time spent is good. It's presumed to be in the best interest of a child to have parenting time with both parents. The child should know both of you. Okay. So, yes, ma'am.
I was saying, like, I agree. I just want to start off slow.
And that's why I'm sending you to the front of the court. So you can start it slow, get the child used to him. Then they'll help you develop a time period so that you have days and times and everybody knows what's going to happen. All right. Have a good morning. Good luck to both of you.
Okay, so we just stay on here until the
No. The front of the court will be contacting you shortly. They'll be contacting you in the next week or two.
Oh, in the next week or two. Also, so we done.
Yeah. Well, I don't know what your work schedule is. I don't know what her work schedule is. I don't know what, I can't give you evenings if you work, second shift. I can't.
Is it okay if I ask you a question?
Go ahead.
How do I appeal for child support? How do I go about that? Because he was granted no child support, and I would like to help because he hasn't been here financially, physically, emotionally, mentally, nothing. And it would be nice to be able to receive some financial assistance.
That's unusual. Yeah. Oh, paragraph 12.
Yeah.
Yeah, you were incarcerated, correct, sir?
Yes, and
all right. This will be part of the parent. I will send that with parenting time and child support because it was. There's something in here. There was a reason he was.
Yes, because I have diabetes and I'm on medical leave right now, so that's why she took me off there because I have a medical condition right now. Yeah, so that's why I'm not paying child support right now, sir. And like I say, and that shouldn't give a person a right to hold my child against me because I can't pay right now because I'm disabled.
Hold on? Have you applied for disability?
I have.
Yeah.
Okay, and I apologize, ma'am. Normally, when paragraph 12, when the prosecutor sets zero support, it's because of incarceration. So I jumped to that automatically. That's my fault.
That's fine. I just don't like the fact that he is lying to you. I've never kept my.
Well, I will have this sent for child support and parenting time.
Okay.
No problem.
I don't like to lie. I'm sorry.
No, that's okay. That's why I'm sending it for a review. I had another case earlier that people were getting along well enough that I sent them for mediation instead of the review, but you guys are going to need the full review, I think.
Yes, we do.
So, all right. So the fees are waived on this because the judge already waived it. So I'll send it for parenting time and child support.
I appreciate it. Thank you so much.
Right, thank you. Have a good morning.
You too.
All right. Thank you.
Take care. That file is just a brand new file and it's already 3 times thicker than some of the other. Yeah, I wasn't even going to go to mediation on that one. I'm like, not from what I'm reading.
Hello.
Good morning, good morning, sir.
Good morning, sir.
All right. You connected, obviously, Miss Sabrell. Did you connect, ma'am?
Yeah.
I'm asking her. I'm asking her. I know you connected.
Yes.
Okay. Welcome. All right. So you guys recently filed for a divorce and judgment was entered October 18th, 2024. There was a previous child support case that started in 2012. So we are going to go on the record of the matter of Sabrell versus Sabrell because we do have a minor child involved, correct?
Yes.
Yes.
Because somebody has mislabeled the file as a DO instead of a DM, which means there are no children involved, and that is completely inaccurate from what I'm reading. So I'm not sure how that happened, but I will make sure that gets corrected. But we're dealing with a 12-year-old child, and child support was ordered in because there's no child support order in here. You just cited to the DS case, correct?
I don't know. Ever since the me coming back to after waking up from the hospital, I don't know what's going on, sir.
Okay, what happened with you, sir?
I had a serious motorcycle accident. And they said I had seizure, and they had to bring me back.
Okay.
And
All right. Whoever is talking with you should not. Okay. Okay.
I
All
whatever they
right.
call
So, all right, Miss Sabrell, do you know of this injury? Do you know what happened?
I wasn't informed about it until way after the fact that
Okay.
everything had already happened. So
Okay, but you do know that he's been drastically injured.
I do know that, yes, sir.
Okay. What is the current child support, since that order is not in this file, since it's only cited to?
The current child support was ordered that he had to pay $82, which was the minimum because
Right.
he wasn't working at the time.
Right.
Before the motorcycle accident. And then he did get a job before the motorcycle accident and they never raised it. And then he got in a motorcycle accident and then they kept it at the 82. So whatever Ottawa County did, they had it at the minimum low of $82 a month. And then
Right. So it hasn't been reviewed in a while then.
No.
Okay, so he has the right to request a review of it every 3 years. So I am going to send it to a review. Sir, what you need to know is that, and ma'am, so obviously you're very injured according to the paperwork that the court has received from you. So what I am going to do is I'm going to enter a 0 support order for now, but I'm reserving that same support to be reviewed as well, just in case you receive disability or something like that, okay?
Yeah.
Now, the other thing is this. If you supply the front of the court a doctor's note saying that you are incapable of working, they will automatically stop support. That's why I'm doing it, ma'am. So I'm just trying to make the process a little easier for both of you, since this is a severe injury. Yeah, they will normally abate. Yeah, they will abate the support. You're just doing this to back it up. Okay.
Right.
All right. So I will send this for a review, and it probably will come out at 0, and the review will just state as long as he keeps giving them a doctor's note, they'll keep it at 0.
Okay.
All right. So I'm granting your request, sir. Is there anything else?
no, I
Okay.
just no,
Okay.
I don't want to mess up anything.
No, you're not messing up anything. I just hope that you get better.
Yes.
Is there a decent prognosis here?
They said I just gotta come to I don't know. They don't I don't understand what's going on.
All right. Well, you just take care of yourself. Keep making the doctor's appointments and any rehab, and let's see if we can get you healthy again. Okay. Good luck with that. But I'll do what I can to assist. I'm sorry, Miss Sabrell, the circumstances I can't control.
No, I totally get it. It's totally understandable. You can't do anything when someone's, had a serious accident like that,
I'm sorry, y'all. I didn't mean to mess this up. I'm sorry.
Hey, no, you're alive. You're alive.
Yeah.
Let's work with that. Okay.
Exactly. One day at a time.
I have a court hearing going on right now where somebody got into a motorcycle accident 7 years ago and they're quadriplegic, and we're working on parenting time there. So be grateful you have a chance of getting healthy again.
Exactly.
Let's do that. Concentrate on that. Make your goals.
Yep.
Get to the doctor, get to rehab. Take it one day. Yep. I think everybody's on board with that. Take care of yourself, sir.
How's my daughter? How's she doing? Is she okay?
She's doing very good.
Okay.
She's doing very good. Okay. She just went to tech center yesterday to try to go into welding. She's doing good.
Good for her.
Yes.
All right.
She's doing good.
All right. Take care of yourself.
I just want to make a quick note on your age. She is 13, actually.
She's 13.
Sir.
Okay. All right. I was reading what you had put on there. They don't put the birthdays in here anymore. So your judgment of divorce said she was 12. And that was just entered about 3 months ago. So she's 13. Good. Yeah. I don't want to offend the 13-year-old.
No.
No. That's at the age that it's like, I'm 12 and a half, Mom. Yeah, I get that.
Exactly.
No problem.
Sorry, my dog was attacking.
All righty. Mr. Sabrell, you take care of yourself and good luck to both of you. Have a good morning.
Thank you. You have a good morning.
You do. Welding. Nice.
Yeah, that's cool.
All righty. 074DS.
Right, for the next three,
Miss
I just have one
Vandenbosch
party
is
here.
not present. Mr. Wiersma is present. This is his motion. Sir, I take it you got a letter from the front of the court indicating an overpayment?
Yes,
Okay.
it's right next to me.
Okay, and because I really need that letter. But what I will do is I will ask the front of the court to send me a copy with your permission. Okay, that way I
Yes,
have
sir.
it so I know how to put on the order. Because I can't tell from your handwriting whether it's 287 or 387. So I have no problem granting you the money back because obviously you're paying zero in support now because the kids are with you.
And the other thing is I haven't received a piece of paper saying that I have temporary full custody of the kids.
Okay. Let me, because we just did this on, what, 3 weeks ago, right?
January 3rd, sir.
Right. I did not send that to the front of the court. Did I set this for a hearing to grant custody?
I thought so, sir.
Okay. Did we have that hearing?
We had the one on January 3rd.
Right, but Ms. LeVay, do we have a hearing coming up on this case?
Let me see.
Because normally I can't do that on a Friday morning. I have to actually bring you in, put you under oath, take some testimony, and then officially change custody. I did it in the child support order by giving you 365 overnights, but I can't change custody on a Friday morning. Yes?
The case, so we heard this on January 3rd. You referred it to front of the court. You did not order a hearing.
Oh, okay. I referred it to the front of the court. Okay.
Correct.
So they will be getting you custody. All right. No problem. Can you double check and make sure that it went to the front of the court? Because I'm not seeing order of reference in the file.
Yes, I can check.
Yeah. So we'll make sure that that gets through, and then I'll work on that abatement for you. Okay?
Thank you, sir.
Kids, the boys doing okay?
Yes. We're just getting a lot of doctor's appointments, trying to get stuff figured out for them.
No problem. Yeah. Get them back in, get them back on their feet, and get them back in shape. They're going to need it.
Yep.
All righty. All right. So I will get this done. We'll get this set so that she pays you, reimburses you the overpayment under the circumstances, and then the front of the court will be issuing that custody review. All right.
Thank you, sir.
You have a good morning. Take care. Yeah, some things I can't cure on a Friday morning. It takes some extra hoops to jump. I cured what I could cure. I cured what I could cure on that morning. All righty. Take care of yourself.
Thank you for your time.
All right. Bye.
Bye.
Wait, sorry. Okay. So everybody has granted backwards on all the pleadings. So Wayne, Mr. Crow, John did it too. He must have just responded. Well, let's face it. I know none of us type our own order or no, our own motions. So, well, your assistant probably got his motion, which labeled him as plaintiff, and then responded in kind.
I think we just captioned it based upon the filing.
That's what I mean. You based it based on yeah. So
we didn't independently research it, Judge.
No. Just to confirm, everybody, Brianna's the plaintiff. Aaron, you're the defendant. It stays that way. Sorry, guys.
No, it's okay.
And this whole case was, neither one of you brought this case. This case was brought by the state of Michigan. So they didn't represent either one of you. They represented the state. This was brought by the prosecutor. I'm kind of assuming that at the time maybe state aid was involved. And when state aid's involved, the prosecutor brings a motion. So neither one of you asked for this case. But that was in 2015, 10 years ago. So we're now dealing with a 10 or 11-year-old?
He's going to be 11 in April.
Okay. All righty. And sir, I've read your motion. What exactly are you asking for?
To be honest, me and Bree kind of talked about it. I think I reacted in a bad way. I think he's too young for me to want to take full custody, and I don't think that it's the right thing to do at this age. Correct. I think that we're probably just gonna. I think she agreed that we're just gonna keep it the same way for his sake.
Okay. Well, if everybody's in agreement and you want to keep it the same way, that's fine too.
Well,
you have the right to request, but I would tell you that a motion for custody under these circumstances would be denied, Mr. Seeley, because you haven't met. You kind of have no change of circumstance to look at this point in time. So yeah. So, but if the two of you are still working together, you've worked together for 10 years now. Then you're about to get a teenager. You're going to need to work better together.
Yep.
Let's face it. You're each about to become a taxi service.
Yeah, agreed with that.
And I read the allegations back and forth. Let's not get into them. Treat each other well. When you talk to each other, sir, you're talking to the mother of your child. Ma'am, you're talking to the father of your child. I give that instruction to both of you to put both of you on the same level. And just remember that, because the child's listening. So, or you never know when the child's listening, because, tell them to clean up their room. They don't hear you 10 times. You whisper something that you don't want them to hear, and they've heard it 5 rooms over. Okay. So try to be kind to one another and be kind to the child, and I'll stay out of your lives, because so far we've done it for 10 years. You got 7.5 more to go. All right. So motion denied. I'll prepare that order, Mr. Crow. Thank you for your response, or thank John for his response. All righty. Take care. All righty. Bye.
Thank you, Your Honor.
Well, that was an easier one than I thought it would be. Okay. 9DP.
Jackson versus Lucia.
All right, I've read your motion. What's going on? I need to know a little bit more. So he's got visitation at Journeys. How long has he been having visitation at Journeys?
He's been having visitation at Journeys about 2 years now.
About 2 years?
Yes, because.
And he's been inconsistent?
Well, he was consistent. Yes, he has. But since December 14, it's been non-consistent. When he moved to Lansing, he just hasn't been to his visitations. It's every Saturday.
Okay, how many has he missed? Because that's why I'm kind of confused as to how long it's been going on and what's actually been happening with it. That's why I wanted more information.
Sorry to cut you off. Saturday, it's every Saturday. So he's been missing every Saturday since December 14th.
Okay, since December 14th, he's missed 3 months.
Yeah.
Okay. Well, it sounds like I'll just go ahead and we'll stop that. He can come back and then ask for it to be restarted again. Everyone has the right to request specific parenting time at any time. But if he's going to be inconsistent, I'm not having you drive over there to Journeys for him not to be there. Okay. It looks as if you want child support reviewed as well. Maybe? Because there's something in here about, the cost have been, it's kind of, it's in there, but not in there.
Oh, yes.
It's not specific.
But okay, so child support for him has been very inconsistent. He has not paid.
He has to have a consistent job because we take it from the employer.
Yes,
but he has obviously changed jobs, correct?
He has not had a job since.
Well, he moved to Lansing. Did he not move for a job?
No.
That would be why you're not getting child support, because we take it from the employer.
Yeah.
So I'm not sure whether
it was for his girlfriend.
Okay. All right. Well, we're going to suspend his parenting time. I don't know whether to review child support or not under those facts, because he's not here. Your request is kind of non-specific, and I'd hate for it. I don't know if it would change all that much. He's about as low as you're going to go, because we're going to hold him to an income. We'll impute him to a 35-hour a week at $15, which is about what he's going to pay now. In other words, what I'm trying to do is not have you, chase a tail that you may not be able to chase.
No, it's fine. I didn't request.
No, the arrears will continue unless he comes in and asks for a support review, because he's going to have to explain why he doesn't have a job. But at this point in time, as long as he doesn't have any mental or physical disabilities, correct?
No.
And therefore he's capable of earning a full-time wage. So we would do exactly what we did the last time, is hold him to a wage. And so I don't think that's going to change the support. So I don't necessarily have a change of circumstance with that. So
I
a
know
change of
some-
circumstance is a change through no fault of your own of your income going up or down. Well, if you walk away from a job, that's fault of your own. Or every 3 years. And this was we just entered an order a little less than 2 years ago. So he can ask, either one of you can ask for it in 3 years, no matter what. I'm just trying to, at this point in time, I'm not going to have you jump through hoops that maybe aren't worth jumping through.
I appreciate it.
No problem. So, but yeah, I'll keep this child support order and I'll suspend his parenting time because if he's not exercising it, I'm not having that child and you waiting at Journeys and the child's crying, wondering why daddy isn't there.
Yeah, yes.
So, all right. Take care.
Thank you so much.
Have a great day. Trying to
too.
get you through it. That's all.
Thank you.
All righty.
Have a great day.
You too. Take care.